Welcome to today's Scaringi Law Lunch Minute. This is the time of day when you can learn a little bit about the law while you enjoy your lunch. Yesterday, we spoke about the pardons process and how anyone with a criminal record in Pennsylvania may be able to obtain a pardon from the governor, and how the pardon and its corresponding expungement results in a complete eradication of one's prior criminal conviction. The most important benefit of a successful expungement is that the person can truthfully and legally say they were never arrested, accused, or charged with a crime, as if the entire incident never happened. This is especially critical for an individual when a criminal background check is performed for applications of employment, mortgages, credit cards, rental properties, bank loans, applications for professional and occupational licenses, concealed carry permits, and for the purchase of firearms. The pardon and expungement process and the result restores all civil and constitutional rights and privileges. The law also affords Pennsylvanians the opportunity to expunge the prior criminal record without having to go through the lengthy pardons process in certain circumstances. The result, an expungement of a prior criminal record, is the same, and so are the benefits as a pardon. So let's talk about the law of expungements in Pennsylvania. First, to expunge means to strike out, obliterate, or mark for deletion, to destroy completely. An expungement proceeding is a type of civil action through which we petition the court and request that it enter an order which allows for the erasure and destruction of your criminal record. If successful, the records are said to be expunged. There are 7 main ways for an individual to attempt to expunge his criminal record. Here are the 7. 1. Expungement after successful completion of accelerated rehabilitative disposition, otherwise known as ARD. 2. Expungement after aging out. We'll talk more about this and all of these later. 3. Expungement of summary offenses. 4. Expungement after charges are dismissed, withdrawn, or something called nolle prosequi or null prost. 5. Expungement after acquittal of charges. 6. Expungement of pardoned charges, which we discussed yesterday. 7. Expungement of certain protection from abuse orders and petitions. So regarding the first of the 7 ways to obtain an expungement, accelerated rehabilitative disposition, ARD, is a diversion program through which a defendant, someone charged of certain criminal offenses, may apply for placement into the ARD program, and if accepted, earn a dismissal of the pending charges. And after successful completion of the ARD program, the individual may apply for an expungement of the record relating to his arrest and the charges. In some counties, expungements are automatically submitted or requested by the probation office or the district attorney's office, while in other counties, the individuals or their lawyers may submit and are required, if they want the expungement, to file the petition and request the expungement. In these cases, expungements are mandatory and the court is required to enter the order of expungement. A tip is, don't forget to do it. After you have successfully completed ARD, one of the chief benefits of that is the expungement. And we've handled several cases over the years for clients who got tripped up later in life because they or their attorney who handled their first offense DUI, for example, never actually went through and completed the steps necessary to obtain the expungement. Regarding the second of the 7 ways to obtain an expungement, that's for an individual who is the subject of a criminal information and he reaches 70 years of age and has been free of arrest or prosecution for 10 years following final release from confinement or supervision. Or in the second scenario, an individual who is subject to the criminal information has been dead for 3 years. This expungement is discretionary, meaning the court has the discretion to enter it or to deny it. And our office successfully obtained an expungement for a deceased person. We did it on behalf of the widow who wanted, for the sake of posterity, to remove this black mark on her deceased husband's otherwise perfect record. Regarding the third way to obtain an expungement, this is for an individual who was convicted of a summary offense and has been free of arrest or prosecution for 5 years. That expungement is discretionary, meaning the judge can enter it or deny it. Regarding the fourth way to obtain an expungement, it's an expungement after the charges are dismissed, withdrawn, or null prost. And in these cases, the court will apply what's called the Wechsler test, which is a 5-point test that I'm not going to get into now, but essentially it weighs the pros and cons of affording or awarding an expungement in these particular matters. This is also discretionary with the court. And the tip is, in some cases, criminal charges don't make it all the way through to completion. They just kind of go away in a colloquial sense. But they don't just go away as a matter of record until and unless you file a petition to expunge and receive a court order doing so. So if you're charged with lower level nonviolent offenses and they never really make it through, they're withdrawn or they're dismissed or null prost, well, that's not the end of it for you. Contact your attorney and make sure that you are filing necessary paperwork to have them removed from your record. The fifth way to obtain an expungement is after an acquittal of charges. A person is automatically entitled to an expungement of a record where the charges resulted in acquittal. So if you go to trial and you win and you're acquitted, you have an automatic constitutional right to have the court expunge those charges, and that's mandatory. The court must do it. Regarding the sixth way to obtain an expungement is expungement of pardoned charges, which we went into extensively yesterday in the Scaringi Law Lunch Minute. But essentially, a person is automatically entitled to expungement of his record for which he has received a pardon. That's mandatory. The judge must enter and grant the expungement request. Regarding the seventh and the last way to obtain an expungement, this is an expungement of certain protection from abuse orders and petitions under the Protection from Abuse Act. Now we're moving outside of the criminal law into the civil law, but PFAs are somewhat associated with the criminal law. But it's not commonly known or understood that when a Protection from Abuse Act proceeding never evolves beyond the temporary stage, where a PFA petition is filed against a defendant and is dismissed by the court, the defendant is entitled, as a matter of right, to an expungement of the PFA record. So if you are the defendant of a PFA that was dismissed by a judge, or if you agreed to a temporary PFA order for a period of time and there was no hearing, it was an agreement, and is to be dismissed after a certain period, and is to expire after a certain period of time, make sure you contact us here at Scaringi Law, and we can obtain the expungement of that PFA record for you. It's a mandatory. The court must do it in these situations. An expungement of a prior criminal or PFA record is one of the most powerful types of legal redress afforded to Pennsylvanians. It can erase your record and restore your civil and constitutional rights and privileges. So don't miss out on this opportunity to restore your rights and your reputation. If you have any questions about Pennsylvania's expungement process, or would like to find out more about how you can obtain an expungement, whether you're eligible and what the process is, contact one of Scaringi Law's expungement attorneys. We have extensive experience in the area of expungement law. For more information on expungements, you can check out our website at scaringilaw.com. Well, that's all the time we have today. I hope you learned something about expungement law in Pennsylvania, and I hope you enjoyed your lunch.